Hi, I'm Gaby Longsworth, a director in the Biotech and Chemical Practice Group at the law firm of Sterne, Kessler, Goldstein Fox. Today I'm going to address the June 2, 2014 United States Supreme Court decision in Limelight Networks v. Akamai Technologies, which held that a defendant may not be liable for induced infringement of a patent under 35 U.S.C. Section 271B when no one has directly infringed the patent under Section 271A or any other statutory provision. In this video, I'll examine the patent at issue, outline the Supreme Court's decision, and provide more detail on the potential impact of this decision, particularly for pharmaceutical and medical diagnostic companies. First, let's take a closer look at this case. Akamai Technologies is the exclusive licensee of the patent at issue. This patent claims a method of delivering electronic data using a content delivery network, or CDN. Website owners, known as content providers, contract with Akamai to deliver the content of their websites to Internet users. The method includes a step of designating certain components of a content provider's website to be stored on Akamai servers, a process known as tagging, and accessed from the servers by Internet users. Limelight Networks operates a CDN and carries out some steps of the claimed method. However, Limelight does not designate the components of its customers' websites to be stored on its servers and requires its customers to do their own tagging. In their June 2nd unanimous decision, one that overturned an en banc decision by the United States Court of Appeals for the Federal Circuit, the Supreme Court emphasized that a defendant's liability for inducement of infringement must be predicated on direct infringement. The Federal Circuit had indicated that a defendant can be liable for inducement of infringement under Section 271B even if no one had committed direct infringement, because direct infringement can exist independently of a violation of the provisions of Section 271. The Supreme Court explained there had been no infringement of the claimed method here because the performance of all the patent steps is not attributable to any one person, and where there has been no direct infringement, there can be no inducement of infringement under Section 271B. The decision further noted that the language of Section 271F1 reinforces the Court's reading of Section 271B because when Congress wishes to impose liability for inducing activity that does not itself constitute direct infringement, it knows precisely how to do so, and further that courts should not create liability for inducement of non-infringing conduct where Congress has not elected to do so. The Supreme Court acknowledged Akamai's concerns that a defendant could evade liability under the Court's interpretation by dividing performance of a method patent steps with another party, but ultimately indicated that this concern does not justify fundamentally altering the rules of inducement liability that the text and structure of the Patent Act clearly require. Now let's take a closer look at the significance of this decision. According to the Supreme Court, for direct infringement to occur, the performance of all the steps of a patented method must be attributed to a single party or person. Thus, if the steps of a patented method are performed by more than one party or person, direct infringement under Section 271A did not occur, and there's no liability for induced infringement. In other words, in the absence of direct infringement, there is no inducement of infringement under Section 271B. As such, the Limelight decision could make it more difficult for patent owners to show inducement of infringement. Proving inducement of infringement may be particularly challenging for certain pharmaceutical and medical diagnostic patents, where the steps in the claimed methods, assuming they have subject matter eligibility under 35 U.S.C. Section 101, could involve actions taken by a combination of testing laboratories, doctors, and patients, and not by any single party. In addition, the Court's decision could also allow active pharmaceutical ingredient, or so-called API manufacturers, to avoid liability for inducement of infringement where the claimed steps in a process patent are performed by two or more parties. Patent prosecutors should continue drafting single-step method claims to avoid a Limelight end-around. Thank you.